Safe harbor. There's no safe harbor.
Well, let me throw this out then. What about the use of Wikipedia images where they've supposedly signed away that it's free, open access?
Sure. You're talking about public domain images.
Public domain. Yeah, thank you.
That's something that's difficult to. The way that copyright works, copyright keeps getting extended for longer and longer terms, and really anything that's been created during our lifetimes, technically, is probably still copyrighted. So in order for something to have actually fallen into the public domain, somebody has to expressly give up their rights to do it. Okay. So if you're at a resource and they specifically say that a picture is public domain, you're probably safe there. Not everything on the internet is correct, so sometimes it can be wrong.
Right.
But just because an image is on Wikipedia or somewhere else doesn't mean that it's public domain. Gotcha. In fact, I tell everybody, if you're going to borrow anything off the internet, I guarantee there's probably somebody who has a copyright in that. And there are search engines that actually search for pictures and look for infringements. Right. So be very, very careful.
And you said they have like billions of hits a day, or what was it you were saying?
There are actually companies that are out there that are able to monitor illegal downloads, and they're so they can actually track it for their clients that are out there. So if you happen to take an image or take a song from, especially through a BitTorrent type system, if you take those images or songs or movies or whatever it is, there might be somebody watching it, because everything on the internet is actually available for everybody in the world to look at, and it does not go away. It's always out there. So keep that in mind.
Steal books.
Yes. And we do have a question that's following up on this. How are monetary damages determined in copyright infringement cases when no money was made on the infringer's part?
Okay. There's two types of damages you can get in copyright infringement cases. One is typically the actual damages, and according to this question, there's probably no actual damages. So the other way that the other types of damages are statutory damages, where the statute recognizes that sometimes there will be situations like that. Statutory damages are set at a minimum of $750 per registered work, up to $30,000. Now, if there's a willful component, if you can show that the person that's the infringer was also a bad actor, you can actually get those damages increased up to $150,000. So even if the infringer, hasn't been made any money, you can actually potentially get up to $150,000 against them. But that doesn't mean that they have the deep pocket to actually pay that. So that's one of the problems you have with, especially with IP law right now on the internet, since it's so easy for people to copy. Normally, even just 20 years ago, if people were going to copy a book or copy anything else, they had to have significant resources to do that. Nowadays, all you have to do is hit, copy paste. And so because of that, sometimes you have to look at it when you bring a lawsuit. If I bring a lawsuit, am I actually going to lose money or actually be able to recover money here? So that's something to keep thinking about in the back of your head. Sometimes you may only be able to shut them down, which is enough, but you have to realize, what's your goal. If you shut them down, you might want to turn the lawsuit off at that point, because you might just be paying more attorney's fees to get $0 at the end.
From an author's perspective, is it a good idea to be an LLC to somehow protect yourself from inadvertently doing something stupid like this?
It's always good to have layers of protection. It's another it depends, type of way to do it. If it's your business of rampantly infringing, you might want to have an LLC, and that LLC is all that's doing all that while you don't do anything.
I don't do anything ever.
Oh, we're friends. What we do.
Exactly.
Yeah. Okay. I don't think I have anything else. Is there anything?
I think we have one
more.
So,
what do you suggest for the people who publish with small presses? Should a writer register all works they publish, or any certain types of works? And what of the works published, i.e., posted, free on the internet?
When you register your works with the Copyright Office, you have to pay a fee for each work that you register. The way I recommend to my clients that every single work they have, they register every work separately, because if you're going to seek statutory damages aren't based off of the number of infringing copies that are out there. It's based off of the number of registrations you have. So an example of this is one of my clients. He made a camouflage pattern that he had a copyright on, and the infringers in the case, they made hats, and they made clothing, and they made they made 30 or 40 different products that were out there. But since there is only one copyright registration available here, the damages were limited to $30,000. However, in a case where, let's say you have 5 books or 5 blogs or 5 separate websites that you're running. If you register each one and somebody infringes each one of those, you go from a potential of $30,000 to a potential of $150,000 because you have 5 for that. So I recommend, for each work, get a separate registration for it, and it even applies for works that are free or given on the internet. If those are registered still, you can, as long as they're available, you can actually still get statutory damages. It's always a possibility.
Are there any areas you're seeing more successful lawsuits involving these kinds of issues?
It's really copyright. I mean, because I do copyright, patent, trademark, a little bit of everything. And right now, copyright is really the hot area. Because when you deal with patents, you have to prove that somebody stole the invention. So you have to prove a number of different, very specific elements. When you're doing trademarks, you have to show that consumers are going to be confused. So it involves experts and surveys. When it comes to copyrights, it's a lot easier because all you need to prove is that the defendant or the infringer had access to your work and that there's substantial similarity. And juries normally can do that. It's normally here's mine, here's the infringer's. They're pretty close, and he admitted he had access to it. So because of that, there are cases that have relatively low overhead to bring them, but you still have a potential big reward. Because of the internet and how it's easier to copy works and commit copyright infringements, copyright cases are dramatically increasing right now, especially through the BitTorrent websites right now. So if there's anyone listening, downloading stuff on BitTorrents, you might want to stop because there's going to be a ramped up enforcement throughout the United States on this area in the future.
Now I have another question.
They always leave.
It's not that I did anything, but no.
Your friend.
Your friend needs something.
Yeah, my uncle, I don't know.
Yes.
No, if you have a work of fiction that's based on a work of nonfiction, like use something as a resource, how does that work? I mean, can you do that?
A work of fiction based on a work of nonfiction.
Yeah.
So,
would that not be the Dan Brown approach?
I mean, it almost seems like, if you're writing a work, historical fiction, basically. I mean, it's an it depends situation depending on how you do it. But really, what you're focusing on is nonfiction or based off of nonfiction is based off of historical facts. And since you can't copyright historical facts, you can actually build off that or do whatever you want. So I mean, and that's why I think historical fiction is so popular, because it takes stories that people know and then adds other characters or adds what the characters were thinking. And in order to write that, you have to do the research. I mean, you can't and because you're basing it off of, because you should be in a perfect world basing it off of facts that you're collecting from multiple resources, you're not technically